As Lisa's indicated, if you have questions, please use your chat bubble. When we put this presentation together and first announced it, it was going to be basically focused on how to handle an OSHA inspection and the decision-making matrix you go through if you receive a citation following an inspection. Of course, Lisa and I discussed that before COVID-19 hit us at the beginning of March. And as a result of that, we've added to the beginning of the presentation, and now we're calling it Pandemic Protection Policies EAP, as you'll see on the slide that should be on your computer screen right now, plus the OSHA inspections during and after. And since last week, actually just a little over a week ago, on May 19th, OSHA issued a brand new policy with regards to your responsibility to track COVID-19 cases. This has changed things significantly because OSHA went from a very laid-back policy to one that is a little more aggressive, to use that term. And so I've actually added something now to the beginning for which you won't have a slide. But when this presentation is over, Lisa will email each one of you an article one of my partners, Abby White, just did at my request, and I've reviewed it for our clients and our trade association clients, and it's basically titled OSHA Raises the Bar for Investigating the Work Relatedness of COVID-19 Cases. So we've moved full circle 180 degrees from where OSHA was prior to May 19th to where it is now, and this policy went into effect on May 26th, just 2 days ago. So I'm going to now start out talking about that. Then I'm going to roll into the Pandemic Protection Policy / EAP, and then we'll get to the major topic. We'll have time to complete everything, but I felt, as I discussed this with Lisa, our goal at the Safety Council is to keep our members and those who participate with us in things such as this program up to date as much as possible, everything that's going on. So what OSHA did, they've taken a position where they really didn't expect you as an employer to do any tracking at all, to a situation where now they have set up a 3-step view. 2 of the steps are pretty basic, pretty straightforward. The 3rd step, though, requires a little more effort on your part. So now, basically, the requirement for recording a COVID-19 case on your OSHA 300 log is, first, the employee has to have a confirmed COVID-19 case, and you'll see this on the article / memo you're going to be getting emailed to you. You have to determine that your employee has a confirmed case of COVID-19 as defined by the Centers for Disease Control, the CDC. And this means that your employee must have had at least one respiratory specimen that tested positive for SARS-CoV-2. So if they have that, then they've got a confirmed case of COVID-19. That's step 1. Step 2 now is it has to meet the regular record keeping criteria, which means that the condition has resulted in death, days away from work, restricted work, or transfer to another job. That can even be looked at by OSHA that the person is quarantined at home. That essentially is a work restriction. So even if they've not had any symptoms, no hospitalization, they've not even seen a medical professional, maybe anything but a phone call, and the medical professional says, we want you to stay home for 2 weeks and monitor your symptoms. That in itself has changed, has created a job restriction, so that by itself could make this COVID-19 recordable in your OSHA 300 log. Then, of course, the other issue is it requires treatment beyond first aid, and therefore is a significant illness diagnosed by a physician or other licensed healthcare professional. But step 3 is the critical one, and that is it's work related. And what OSHA has now established in its previous guidance, OSHA recognized the difficulty that you would have in determining work relatedness. And What they've done now is they've said you must use reasonable efforts to determine work-relatedness. That's the new criteria. And reasonable efforts means you have to really investigate the claim and the employee who's filed the claim, whether it's workers' compensation or not. But I tell my clients who are in states with private insurance for workers' comp, you can't rely on the insurance company, just like you can no longer rely on a determination by the Ohio Bureau of Workers' Compensation, if you're an Ohio employer, as to whether your employee's COVID-19 claim is or is not compensable. So effective May 26, you have to make reasonable determinations as to work-relatedness. So you must take affirmative steps now to question your employees with confirmed COVID-19 cases that meet the record-keeping criteria I've already mentioned to you, rather than just rely upon information that you might learn through the regular course of managing your business. So you now, OSHA says, you should ask the employee how he or she believes they contracted the COVID-19 illness. The second step is, while respecting the employee's privacy, you need to discuss with the employee his work and out-of-work activities that may have led to the COVID-19. This is where things get a little dicey. And I suggest here you chat with your employment law counsel to make sure you don't cross any privacy lines under ADA or any other employment law regulation that prohibits certain types of inquiries, because OSHA is saying you should pull that employee aside, sit them down and say, okay, now, why do you think you got this COVID-19 while working for this company? And secondly, what else have you been doing over the last couple of weeks? What exposures have you had? Do you go to the grocery store? Have you started now that the regular retail stores have opened up? Have you gone shopping to retail stores, which you may not have gone to before? And things along those lines. So that's the second part of the inquiry. And in addition to that, OSHA said, well, if you've determined that, let's say you're a machine shop and you employ 25 or 30 people in your machine shop. Now there's 25 or 30 people, half of them have been diagnosed with COVID-19. Whether or not they've been work-related cases, if 50% of your employees have been diagnosed with COVID-19, OSHA is saying that is evidence that a reasonable employer might consider that the COVID-19 diagnosis is related to the employee's work for you, and they probably contracted it at the place of employment. So those are the kinds of things that you need to be looking at as you move forward in investigating this situation. The key takeaway from this whole, the memo you're going to get, and from my recent comments, the key takeaway for you is you can't just make a conclusion based on the course of your business and say, well, I just don't think anybody could get COVID-19 working for me, just like I would say here in my law office. I don't think anybody who comes to work here could ever get COVID-19 because we all social distance, we wear masks when we're in public areas. So therefore, there's no way you could have gotten your COVID-19 working here. That's not enough anymore. You now have to inquire the employer. I would have to sit down with my employee and I'd have to say, okay, where do you think you got COVID-19? And if my employee said, well, I think I got it coming here to the office. Then the next question I'd have to ask is, why? Why do you think you got it here? And after they gave me that reason, then the next inquiry would be, tell me what you do when you leave here every day or before you come in here every day for the last couple of weeks. Where have you been going? What have you been doing? And then I need to evaluate that information and investigate as far as I need to make a reasonable, and that again, you'll hear me say this as we go forward with the other materials today. Reasonable is what I call a lawyer term. Why OSHA uses it, I have no idea. Reasonable is an undefined term. It's the kind of thing that keep litigators like me in business. Let's be honest. Nobody knows really what reasonable means. Actually, reasonable may mean one thing to Lisa, it may mean something else to Gary, it may be something else to Patty or Bill or Phil. We all have our own definitions as what is reasonable. And what OSHA is saying is, and now we're not talking general duty clause, we're talking 1904, which is the record keeping requirement rules, OSHA standards. So don't forget here, this has got nothing to do with general duty clause. This has got nothing to do as to whether you're providing your employee with a place of employment free of recognized hazards that are causing or likely to cause death or serious physical harm, which is the standard for whether or not you're taking sufficient precautions in your workplace to protect employees. And we'll get to the upcoming slides here in a few minutes. This is now a record-keeping violation. OSHA rolls in and they look at you and they say, how many COVID-19 cases do you have or employees do you have that are out with COVID-19? You say, well, I've got 5 that are out with COVID-19. Let me see your OSHA 300 log. Why are none of those employees listed? And you're going to have to justify the fact that you've made a reasonable inquiry to make a determination as to whether the COVID-19 was work-related or not. Said enough, you're going to get the memo. As I often offer, and I'll offer today, for those of you who are on this webinar, if you have a question about that, please feel free. You can see on the slide that's on the screen right now, and you're going to get copies of the slides. Please feel free to email me. Just please tell me, hey, I was part of the Dayton Miami Valley Safety Council webinar you did, Gary, on May 28th. And I know it says 8 a.m. We didn't change the time before the slides were changed. We changed the time of the webinar. I was on that webinar. I have a question with regards to something you said. Get one shot at me for no charge. Please feel free to email me and I'll try to answer your question. With that said, let's move on to Lisa. For some reason, I've lost control of my slides.
Okay, Gary. Let's see here.
Okay, we're going on to the first slide here as soon as I can get control.
I'm going to double check again, Gary, and make sure. Oh, there you go. Okay, all good.
Okay, the first slide is emergency action plans. If you read the title to this of the presentation, it was Pandemic Protection and EAPs, and I wanted to distinguish the two. So I have the first slide or two here is going to talk about emergency action plans. Emergency action plans are covered by specific OSHA standards. If we're in construction, it's 1926.35, and if you go to that standard, or 1910.38 for general industry, you are going to find a long list of requirements for your emergency action plan. And emergency action plans are intended to deal with the kinds of emergencies that you see on this slide: fires, explosions, workplace violence, civil disturbances, natural events, hurricanes and tornadoes and floods. Anything that could occur or impact a workplace that could expose your employees to an injury should be covered in your emergency action plan. And quite frankly, if you don't have an emergency action plan, you better get one, because one of the things OSHA is going to be doing, and I've been seeing an increase in these kinds of inspections with my clients when they come out and they're going to ask to see a copy of your EAP, because then the next thing they're going to ask is, let me see a copy of your pandemic response plan, which is here. Now, first, there is no standard that covers a pandemic response plan. One thing I've been preaching to my clients, and I've done, I can't tell you how many webinars for my trade association clients in the last 2 months, probably I've done at least 4. My firm has done about 6 or 7 on all aspects and impacts of the pandemic on businesses, everything from force majeure clauses and contract language to safety to employment law. But the point is, there is no OSHA standard, and its pandemic protection policies or plans are not covered by the emergency action plans, because the pandemic is not something contemplated by the standards that address emergency action plans. One of the things I've said, though, is that this is the first really clean, for lack of a better term, really clean hazard to be enforced under the OSHA General Duty Clause. This is the General Duty Clause I've already recited to you once, requires you to provide your employees with a place of employment free of recognized hazards that are causing or likely to cause death or serious physical harm. That applies to both general industry and construction, and in fact, it applies to office and retail environments also. We're all covered by OSHA in one way, manner, shape, or form. The General Duty Clause OSHA was chastised in the Sturgill roofing case, which was decided a little over a year ago, where OSHA said, hey guys, the review commission said, hey guys, OSHA, you were overusing the General Duty Clause. The General Duty Clause is looked at as a stopgap. It's looked at as to be used by you, OSHA, when a new hazard enters the work environment, not contemplated by an existing OSHA standard. When Congress passed the Occupational Safety and Health Act and established Section 5A1, the General Duty Clause, they basically contemplated that while you were working to develop a standard to cover that new hazard, employers were on notice that it is a recognized hazard, and you could inspect and enforce workplace safety through the General Duty Clause. And in Sturgill, they said, hey, that was a heat illness prevention case. You've known there's been problems with heat illness going back to about 2010, 11, and 12. That's nine, well, it was 7 years ago last year when the decision came down, and you've not even issued a notice of proposed rulemaking or an advance notice of proposed rulemaking. You've not done anything, OSHA. You continue to try and cite employers under the General Duty Clause, and that's not what Congress contemplated the General Duty Clause to be used for. So you're really messing up here, and you better start, straighten up and fly right, as the old-fashioned expression goes. So that applies to things like combustible dust, which right now is under General Duty Clause, heat illness prevention, workplace violence, distracted driving and distracted working. And they've all been on OSHA's radar screen for at least the last 7 to 10 years, and OSHA has not done anything on any one of them to even start the process of rulemaking. However, here we now have the COVID-19 coronavirus pandemic. There's something that we just became aware of within the last 6 months, and it's a perfect situation for OSHA to employ the General Duty Clause. So therefore, everything with regards to how you protect your employees is going to come within the General Duty Clause, even to the extent that you're required to have a pandemic response plan. So it's going to be covered by the General Duty Clause, and it's tricky for you and me because OSHA has not even issued any directions or directives, at least with heat illness prevention. Through the National Institutes of Occupational Safety and Health, OSHA has given us a 5-step plan component. You need to have these components to your plan. That's what they told us. For heat illness, we don't have any guidance like that or any direction like that from OSHA on the coronavirus pandemic. We've got guidance and recommendations, but boy, some of them are so, as I call it, weasel worded, that it's very difficult, if not impossible, to even interpret what OSHA is asking you to do. But you're going to need to have a pandemic response plan. Coronavirus has put that on the radar screen. And as I said in that last comment on this slide, I see this as a new and continuing requirement. Even when, and I'm hoping there's a when, we bring coronavirus under control with a vaccine, and it's nothing more serious than the flu that we've dealt with for many years, which doesn't require a pandemic response plan. There's no longer a pandemic. That doesn't mean you don't need a pandemic response plan. Your pandemic response plan needs to be general, should be broad for your company. Basically, that's your pandemic response plan for the company. And then under that, maybe pandemic response plan A is going to be the coronavirus. And that's when you'll be able to pull off the table when there's no longer, when CDC and OSHA tells us, well, there's no longer a pandemic now with coronavirus, we've got it under control, you'll pull back because you don't need it anymore. But initially, you need that plan. And then under that plan, also that general broad plan says, when a new pandemic has been identified, this company will move immediately to develop specific requirements for this pandemic. As I've indicated here, now you need a COVID-19 response plan, and it should have work rules, training requirements, and enforcement requirements. Just like anything else you do with OSHA, even fall protection or anything else, we need work rules. We need to show that we've trained our employees, and we need to show that we enforce those work rules and training to make sure our employees protect themselves from the hazards we've identified, whether it's falls or a pandemic. So, general work rules. And that's general again, because as you'll see from the next slide, which we'll get to in a minute or two, you need a site-specific work rules and pandemic plan also. But right now, general work rules, which are pretty much cover the situation nationally. Number one, stay at home if you're sick. Take your temperature and note the symptoms you have every day. We have that requirement today. In my building, I'm at the Premier Health building downtown. Our landlord just issued a requirement that said when you come to work, you have to certify that you've taken your temperature and you have no symptoms which have been identified with coronavirus. If you have a temperature of over 100.4 or you have symptoms identified with the coronavirus, stay home. Self-quarantine. Talk to your doctor, who will tell you probably you need to stay home and self-quarantine for 10 to 14 days. And your doctor may or may not write a note for you to go get tested, whatever. But that's step one. Number two, general, wear face covering and when you should do it. In this building where I'm working, we're required to wear a face covering whenever we're in a public area. In my law firm, we've established the same requirement. Right now, I'm in my office with the door closed. I don't need to wear a face covering. When I walk outside the door of my office, when this is finished, when we're finished with this webinar, I'll need to have a face covering. And don't forget the term is face covering. We're not talking about a respirator. We're talking about a face covering. And here's the reason why we need a face covering, because of number three. This should, again, is a general requirement. If you don't have a face covering, but you cough or sneeze in your elbow. Why? Because a face covering is not intended to protect you from getting coronavirus from someone else, because the coronavirus enters through any mucous membrane on your body, which includes your tear ducts. So unless you're wearing a face shield and a face covering, or a mouth and nose covering, you're not fully protected. The idea, though, between the face covering is to keep you, if you cough or sneeze, and if you have COVID-19, from spreading it to other people. Show social distancing. This is interesting. Right now, the accepted distance is still 6 feet. Although I've got to tell you, as I've been following this in the last 2.5 months, I've seen everything from 6 feet to 10 feet to 25 feet. I've seen, if you look at the social media, or if you have an Apple phone and you follow Apple News, you'll see, okay, CNN just reported that somebody said that COVID-19 can stay active, floating around in the air for 48 hours. And that was pretty quickly disproved, because that was done under less conditions in a vacuum, and quite frankly, in a vacuum it might, if you stir the air in a vacuum. But in real life, because of gravity, anything which is heavier than air, which is sneeze, droplets, they're going to fall to the ground. Social distancing, that comes back to I mentioned right to 6 feet. Employees shall not share equipment, including cell phones. That's a general requirement, would apply no matter where you are, what state you're in. Because don't forget here, your goal here is we are taking steps. We are providing a place of employment free of recognized hazards. And so far, from CDC and OSHA, and in probably 90% of the state determinations, departments of health with the different states, they basically said the things I've mentioned 1 through 5 as basic requirements for you to provide a place of employment free of recognized hazards to your employees. Washing hands frequently and sanitizing all work areas. These are all key components of your general work rules. Again, don't forget we have a general pandemic protection plan that says what we're going to do if somebody announces, CDC announces a pandemic, this is what we're going to do. And then we're going to develop our general work rules, which is we have here. And then we're going to go from that and say, okay, now we're also going to be doing site-specific plans. If you're in construction especially, and you go from state to state, or maybe you're not in construction, maybe you're in manufacturing, and you have a facility here in Ohio, but you also have a facility in Nevada, or in Iowa, or in Utah, wherever. You need, therefore, to look at what the requirements of those states are. I just dealing right now with a client who told me he was told he just did a closing conference with an OSHA compliance officer in Nevada. He's got an operation in Nevada. And this person was driving by and saw that my client had 2 people in a scissors lift. And while that's not prohibited by OSHA or by CDC, the governor of the state of Nevada about 6 weeks ago issued basically some of the kind of things that Governor DeWine has been doing. But this governor said, I find that to provide social distancing, only 1 employee can be in the basket of an aerial lift or in the basket of a scissors lift, because he said you can't be more than 6 feet. You can't have 6 feet or more distance if you have 2 people in one of those. He also said he banned crew cabs. He said there's no way you can put 2 people in a crew cab or in a truck cab or a car and have them be 6 feet apart. So if your employee is being transported from the shop to the work site, either they have to drive their own vehicle or you have to give each one of them a company vehicle, because we are banning having more than 1 person in a vehicle. And that was the governor's recommendation. Now, whether that equates to, because it tends to conflict with federal OSHA for the general duty clause, but the bottom line is about 2 weeks ago, unbeknownst to my client, Nevada, which is a state plan OSHA state, Nevada OSHA, said we're going to create an emergency temporary standard adopting the governor's recommendations. So even though my client had not been made aware of this, there's now a Nevada standard, a numerical standard that prohibits more than 1 person in a scissors lift or in a bucket on an aerial lift or any other aerial lift device, mobile work platform. So all of a sudden my client is now threatened with a serious OSHA violation in Nevada for that very thing. So this is what I'm talking about when I'm talking about state specific. And my point here is, if you have manufacturing facilities in a half a dozen states and they're all different, you are going to need a half a dozen site-specific pandemic protection plans, which are going to be taking your basic work rules and expanding those to cover these additional new concerns that we have. Be aware of the local rules and regulations, and remember, they may be, some of these things may be enforced by county and or state health departments. And also remember, the general duty clause, to say it one more time, requires that you provide a place of employment for your employees which is free of recognized hazards that are causing or likely to cause death or serious physical harm. And those edicts by a governor, edicts or standards or rules established under a state plan, state OSHA, or rules in a state, and we're talking about a pandemic here, that's enforced by the county or state health departments, are all putting you on notice of a recognized hazard that is causing or likely to cause death or serious physical harm to your employees in those states. And in those states, under that state plan, you can be cited under that state's general duty clause because you are not in compliance with their interpretations by their Department of Health, which identifies a recognized hazard or expands on the federal recognized hazard and drills down and says we deem having two people in an aerial lift is a recognized hazard in this state, Nevada or Ohio or whatever other state you might be in. So you need to develop a separate site-specific plan for those sites you have in states outside of your home state, which I'm guessing for most of you is Ohio. You need to develop, and that's how far you have to go. Okay, I told Lisa when we put this thing together, I take about 30 minutes on pandemic protection. That's about what I've taken. Let's move on to the topic, the main topic of this webinar. Why is OSHA knocking at your door? And this is where how you deal with an OSHA compliance inspection begins. As an aside, I have seen an increase, and I'm not sure, I don't think it has anything to do with the pandemic. I've seen an increase probably in the last 6 months of first-time OSHA inspections with many of my existing and some very new clients who called me because OSHA was knocking at their door. And they're saying, Gary, I understand you do OSHA defense work. And I said, yes, I do. And of course, the question is, how can I help you? Well, I've just been told that by my receptionist that there's an OSHA compliance officer seeking entry into my tool and die shop, or seeking entry into my manufacturing facility. Or there's an OSHA compliance officer, my foreman tells me, standing at the job site he's supervising. What do I do? How should I handle this? And as I indicate to them, the first thing you need to get your hands around is, what is the likely reason this person's here? It could be an employee complaint, which, and my personal statistics may well disagree with OSHA statistics, but I feel is probably the major reason we're getting OSHA to the job sites. And again, I can't get away from the pandemic situation. Since we've got the pandemic in place, I've seen an increase in employee complaints. I've got at least 8 or 9 clients who've had employees write complaint letters to OSHA because they don't feel that their employer's providing them a place of employment free of recognized hazards under the pandemic, because the employer's not making everybody aware of face coverings or whatever. That can be the reason for the complaint, and that's why it's so important to know exactly how to respond to that complaint, because we don't want to go to the next step where OSHA comes and knocks at your door and says, I'm here because of this employee complaint, and I want to interview your employees. And that may get them out to the shop floor. They may say, I need to go out on the shop floor because this employee complaint says you're not requiring social distancing, you're not requiring employees to wear face coverings, etc. And once the person gets out there, anything else they see, machine guarding, lockout, tagout violations, fall protection in construction or in any area, also becomes a citable item. So the employee complaint gets them there. So is that the reason? Do you know? Did you get an employee complaint letter and you responded to it? Did OSHA tell you whether or not they accepted your response? And they said, no, we don't accept your response. That's what's brought them out here. And don't forget, when an employee complaint is filed and you get the letter, you have 5 working days to respond to it. Your response is shown to the complainant, the employee who made the complaint. And that employee may say, no, they're lying. They don't require social distancing. They don't require face coverings. They tell employees all to share tools, whatever. So that's the reason OSHA shows up, and that's going to determine to a certain extent how we handle the inspection. The next reason is self-report. You know whether they're there because of a self-report. That's a catastrophic accident. Under the new OSHA reporting rules, you're required to report an accident that results in hospitalization within 24 hours of the accident for treatment, and that's of any one employee, or a fatality, or the loss of an eye, or the amputation of any body part, which could be the tip of a finger. Those are all self-reports. You have to report those to OSHA, and if you've made one of those reports, you should have a fair idea, if OSHA shows up within 1 or 2 days, to 1 or 2 months from when you make that self-report that that's the reason they're there. And again, that's going to help us determine how we conduct the inspection. And another one is the third-party report to OSHA. They've shown up because somebody's called up and said that, let's take you, say you're a roofing contractor, and you're doing a re-roof on a house, and the next door neighbor is concerned because they've seen all these people working on a 2-story house and none of them are wearing any kind of fall protection. And they've seen enough on the TV news today, especially now, to know that in that situation, that's a hazard. And they call OSHA. Hey, you ought to get out here. My next door neighbor's getting a new roof put in their house, and the contractor's got all these employees crawling around all over that roof, and nobody's wearing any protection. And I don't see anything else to protect them in case they fall. A follow-up action, that's a follow-up to a prior citation. OSHA's issued a citation, you settled it, or you litigated and lost it, or you never even fought it, you just paid the fine. OSHA comes back in and they have probable cause to do a follow-up. Emphasis programs, we're still looking at a national emphasis program in fall protection in construction. That's still good cause, probable cause for OSHA to come out to do an inspection. General schedule, this is a drive-by, like the one I was mentioning that my client just had. They drove by his job site and they saw 2 employees in the scissors lift or bucket truck. And that triggered the inspection. But can we limit that? Yes, we can. And that's what we're going to talk about. And then violations in plain sight, which ties into that general schedule wall to wall. So an employee complaint, if that's the reason OSHA's there, so let's say we've got this compliance officer standing at my receptionist desk and he or she is seeking entree into my manufacturing facility, and you got the call. What's the first thing you're going to do? My recommendation would be you tell your receptionist, ask Mr. Smith or Ms. Jones to have a seat there in the lobby, and I'll be with them in a moment. And then get your rear end out of your chair and get down there. You don't keep them cooling their heels for an hour or two because you're the boss. You want to assume that this inspection is going to go forward, and working on that assumption, you want to be as cooperative as you possibly can with these individuals while protecting your rights. So the cooperation here is the first thing is you get down there to meet with that compliance officer. First question you ask them, and I want you to ask them that question, or your corporate safety director, whoever you've got that's in charge of safety and OSHA. Why are you here? They're required by law to tell you why they are there. And when they say that, they'll say, in this case, well, we received a complaint by one of your employees. And I possibly misspoke a minute ago. I said, you'll know it's an employee complaint because you just responded to an employee complaint letter. Some employee complaints, you don't get that informal complaint letter that you have to respond to within 5 working days. Depending on the nature of the complaint, especially if it's something like fall protection, OSHA may roll the troops right away, and you might have somebody out there, you don't even know that a complaint was filed. But once they've identified that it's because of a complaint, then the next step is, I'd like to see the complaint. They are required to show you a copy of the complaint. Now, don't get your hopes up. You're not going to get to see the name of the complainant. That's treated as confidential. It's going to be blacked out or crossed out. Somehow it's not going to be on the copy they show you. Once you see the complaint, now we can determine, or you can determine, how to limit the scope of the inspection. And let's say you're in a manufacturing facility and we've got a manufacturing floor that is, let's say it's 150 by 150 feet. And you look at the complaint that says machine number 15 is not guarded to protect employees from in-running nip points or whatever. Or we have there's a 60-ton part revolution mechanical power press, and it's repeating, and there's no protection when it repeats from a person getting his hand into the point of operation. Things like that. there's going to be enough information, hopefully, to identify where the complaint item is. And you need to make up your mind right then that you're going to walk that compliance officer directly to that location, preferably outside the building if you can, in the rain or snow or whatever the weather is. You're going to go with them, but you're going to get them to as close to that piece of equipment without having to have to show them the rest of the manufacturing as possible. Because when they get out there, anything they see that might be or they conclude is a safety violation is going to be citable, even though it's not the complaint item. If they see it going to or coming away from the complaint area. So then you're going to proceed with the opening conference. And I think I've got another slide on this coming up, but let me just mention, this is critical because you're going to use to set the parameters for the inspection. You're going to identify how many employees are going to be interviewed, and you're going to do all the interviews in your office area, not on the work floor. In the construction location, you're going to put into the job trailer, clear everybody else out, and say, here's the OSHA compliance officer. He needs to interview Pete, and after Pete, he's going to need to interview Bill, and after Bill, he's going to need to interview Phyllis, and after he's finished with those 3 interviews, then you can have the office back, but he's going to use them one at a time to interview those people. And in a construction area, I always tell my client when OSHA shows up, and I think I have a slide on this too, is to pull the employees off the job site. Temporarily shut the job down, because even while you're talking to the compliance officer, if they're looking at the job site, anything they're seeing becomes citable. But employees who are not involved in the inspection, let them continue to work. If you're comfortable that they're working safely, don't forget, if you permit them to work during the inspection, if they do unsafe actions and you don't take disciplinary action against them immediately under your safety enforcement program, you're going to get cited for the things they've done that were unfortunately you were not wise to permit them to do that. So you know your employees, you own the business. You should know the people who work for you. You've got a 20 or 30 or 40 person tool and die shop or other manufacturing facility, or you're running one construction crew with 10 or 15 people, you should know the people who are out there. You should know their reputations. Do they work safely? Hopefully you've been enforcing your safety program, and you should be able to make a judgment call by just asking the foreman, hey, are these guys, they know what they're doing? Are they going to continue to work? Are they going to work safely? And if you get a yes to that, you may consider letting them go back to work. The other reason you want to let them go back to work is you have no idea how long this inspection is going to last. It could last for an hour or two. It could last for a day or two. It could last for a week or two. And whether you're in a manufacturing environment or in a construction site, you've got time limits involved in what you do. And you need to know you've got to get everybody back to work as soon as possible. So you need to make that judgment call right away so you can put those people who need to get back to work, back to work. Second type of inspection that occurs is because of that self-reported injury. Here's where you have somebody who is just hospitalized within 24 hours of the accident. Don't forget, that's a requirement. If the person was injured, let's see, right now it's about 12:15 on May 28th. Let's say that in-person was injured right now, 12:15 of May 28th, 2020. And they go to urgent care, and the urgent care doctor says, I want you to see a specialist, but right now I'm going to set your arm, and I want you to go home and rest. Don't use that arm. And now you have, as the employer, you have an OSHA recordable. And I want you to take till we can get you in to see the specialist, and that's not going to be until 11 a.m. day after tomorrow, which will be May 30th. Forget it. I know it's a weekend, and you know it's a weekend then, but bear with me in this hypothetical. And then you go to see the specialist at 11 a.m., and the specialist says, I need you in the hospital right now. I've arranged for you to be admitted to Miami Valley or Kettering or whatever. I want you to get in the hospital, and then next thing you get as the employer is a phone call from that employee saying, hey, Mr. Smith, you know about that accident I had where they think I broke my arm, etc. They just admitted me to the hospital to get that. I'm going to have to have surgery. They're going to have to put pins in or something like that. I'm going to be here for at least 24 hours or at least overnight. At that point, I wish I had you all out in front of me, because right now I'd ask you, show of hands, how many of you at that point would report that to OSHA? I've got an employee who was just hospitalized for a broken arm. I hope none of you would, because it's more than the hospitalizations now occurring more 24 hours after the accident. It's recordable as soon as they need treatment from a licensed healthcare professional. As soon as that person sets their arm temporarily and puts a temporary cast on there pending review by the specialist, as soon as that happened, you have a recordable. But you only have a reportable if they're hospitalized within 24 hours of the accident, which was on 12/15, May 28th, so they have to be hospitalized prior to 12/15 on May 29th. Anyway, so you've made that report of a catastrophic accident. My recommendation here is, and I'm telling folks this because too many of you don't do it, and I'm not fishing for business for myself or for my fellow attorneys, but I suggest you call your attorney when you have a catastrophic accident that you know is going to require you to call it in and report it to OSHA. You're 99% sure it's going to result in an OSHA site inspection because of the nature of the injury. Call your attorney. Because don't forget, in addition to OSHA citations that you may receive, here in Ohio, there may be workers' comp safety issues, Ohio-specific safety requirements, which could add significant fines to the cost of this injury that you have to pay directly, just like you have to pay an OSHA fine. It could involve a third-party lawsuit, subrogation. There could be a lot of things that get drawn into this because it's a hospitalization case which has resulted in the need for you to call in OSHA. And once those OSHA citations are issued, you don't know what else may develop. As Ohio-specific safety requirement violation, the employee has 2 years from the date of injury to file for that. So if OSHA comes rolling out and issues citations, and that employee has already got a lawyer for his workers or her workers' compensation claim, that lawyer is going to get the OSHA citations probably within 6 months of the inspection. It's going to be well within the 2-year period for them to decide whether they're going to file for an additional award for violation of a specific safety requirement. So bring your attorney into the picture early. At least get their advice. It doesn't have to be a long call. Most calls I can handle like that, I can handle within 5 or 10 minutes. Because I don't have enough information to do much more than say, okay, OSHA's going to be out to see you. Here's what I want you to do if they show up. Here's how I want you to handle it. I give my clients a few bullet points of things as how that OSHA compliance officer when he or she arrives at the site. The third bullet, when possible, try to get the attorney to the site as soon as possible. This is depending on the severity of the injury. If it's fatality, absolutely. You want them to do initial witness interviews, hopefully before OSHA gets out there to do their witness interviews. I want to nail down their statements. And those statements, if they're taken by your attorney, are protected under the attorney-client privilege. But it's sure nice when your lawyer has these sworn statements, an affidavit, which a lawyer can take as notaries to compare against what they end up telling OSHA when OSHA comes out, because OSHA compliance officers, many, not all of them, but many of them, tend to overly magnify the situation and the injury and tend to immediately try to assign fault against you, the employer. And when they're doing that confidential interview with their employee, you have no idea what they're saying to him or her to get them to give that statement, which may be enough to expose you to significant fines or penalties. But it's nice if your attorney's already got those affidavits, your attorney's trained in interviewing witnesses, and has been able to do a non-prejudicial, let's call it, interview and get it down in writing as an affidavit. Gives you a leg up to later on contest the claim. I just won an OSHA case in Arkansas within the last 2 weeks. I won it because OSHA finally recognized the fact they didn't have a case because roofing contractor, I have 4 employees on the roof using warning lines and safety monitor. The safety monitor has his location nailed down, and the 3 employees who are working outside the warning lines. And the OSHA compliance officer who never climbed the ladder to look on the roof, didn't get on the roof, never climbed the ladder, stood down below and took a picture. And all he got were the 3 employees who were working outside the warning lines in the 6 feet between the edge and the roof edge. And he cited my client because he said, you didn't have a safety monitor. My client kept saying, we did. And he says, well, they're the 3 employees. And then he took another picture of 3 employees, but it turned out one of those 3 was a safety monitor with a vest. And my safety monitor did a diagram of the roof, gave me an affidavit. I didn't have to go to Arkansas to take it. We did it over the telephone. Then I had it transcribed, and they found a notary. And the employee said, hey, I was on the roof. I was one of the employees. Yes, it was the safety monitor. It was Joe Yetta. And finally, OSHA agreed that they didn't have any evidence because their compliance officer didn't do a sufficient inspection. And that affidavit was enough to get them. They just told me, like I said, 2 weeks ago, they're withdrawing the citation. So my client's serious violation has gone away. The serious citation was for $7,500 because it was a fall protection violation. Total legal costs were probably less than $500 in phone calls. And we got rid of it because we did our homework up front rather than waiting until it was. It's a self-report and serious injury. Your attorney's on site when OSHA is there, arise, and he or she can set protocols for OSHA to proceed. Don't forget again, this is in a serious case. A good OSHA attorney will be able to tell you when they need to be there or not. You want to be careful. Your lawyer's not looking for fees here. You want to be sure your lawyer is helping you. They're there to help you. They should be able to look at the case if they have any experience in the area and make a call right away. Lisa, I've lost my ability to move my slides again. They should be able to tell you very quickly whether they need to be there and give you a reason why they need to be there. Help, Lisa.
I'm checking, Gary.
I'm not moving. Nothing's moving.
Nothing's moving. Let me make sure you are still made as our presenter. Yes, you are the presenter. There you go. I think they're working now.
You want to establish a protocol for the inspection yourself. You might want to have your attorney available by telephone. A good attorney will tell you that. They'll say, hey, I don't need to be there, but because of the nature of this injury, I will be in my office when OSHA, you let me know when they show up, send me an email, and I'll try to stay available the whole time. So if you have any questions about how the thing is going to proceed, you can call me and we can talk about it. And like I said, while this sort of inspection may be a little more involved and take longer, it's just a standard, like a complaint inspection on steroids, as I said, and you want to follow some general protocols. Okay, if they're out there because it's an emphasis program, moving along here, you want to limit the inspection to the concern of the emphasis program. An example, a case I had right here, just outside of in a community. I can't identify where the employer was because it's confidential, but let's say it's in one of the counties immediately contiguous to Montgomery County, one of our adjoining counties. And OSHA showed up on a power press. There's a national emphasis program on power presses. And they had nothing better to do, but they identified through the various industry codes, they identified businesses that use power presses. So a compliance officer showed up at my client's facility and said, I understand you do this kind of work. Do you have any power presses? My client was smart, very honest, didn't call me. I wasn't involved at this point. I said, yes, we have 2 power. Well, I'm here because of this national emphasis program. I'd like to go out and inspect those 2 power presses. Client still didn't call me, which was fine. He established those protocols and he walked the compliance officer out to the power presses. Now, he didn't take him outside as I would have recommended. He walked him through the rest of the shop. And then on the way back, after he inspected the power presses, the compliance officer found nothing wrong. He's walking back with my client, and he sees a press brake, not a power press, but a press brake, two different things. And he said, "Oh, what's that?" And my client said, "It's a press brake." He said, "Oh, it's a press." I go and examine it. He says, "No, it's not a power press, it's a press brake. It's manually operated." Well, I still want to investigate it. My client said, "That's not part," he attended one of these programs, in fact. He says, "That's not part of what your the national emphasis program is dealing with, because it's not a power press." Well, I want to go see it. Well, let me call. I got to call and ask about this. Let's go back to my office. They go back to the office. My client called me, and he said, "I said, put the compliance officer on the phone." So I get on the phone with the compliance officer, and he tells me that's what he wants to do. I said, "Fine." Put my client back on the phone. I said, "Keep this line open." I got on the second line, and I called the area director in Cincinnati, who at that time was Dick Gilchrist. And I said, "Mr. Gilchrist, I've got a situation. Here's what it is." And Mr. Gilchrist says, "Can you get the compliance officer on the phone?" I said, "Yes, I can. Do you mind if I stay on?" He said, "No." So I called my client. I said, "I'm going to patch in Dick Gilchrist, who's the area director. Put the compliance officer on the phone." He puts him on the phone. And I said, "Okay, Mr. Gilchrist," he's on the phone. And he asked the guy, he said, were there power presses at that location? He said, "Yes, there were two." And he said, "What are you still doing there?" He said, "Well, I found a third one." He said, "What did you find?" "There's a press brake." And Dick said, "That's not a power press. You're done. Leave." And that was it. It was over. No citations issued. And it was cleanly handled. Like I said, the only mistake my client made was he didn't take the guy around the outside, because if he'd done that, we wouldn't have even had to have the phone calls, because the man would have never seen the press brake. He saw that only because he was walking through the facility, but my client knew enough that the compliance officer was exceeding the scope of his rights under a national emphasis program. And there can also be regional emphasis programs. Right now, trenching is a major regional emphasis, and that's in our region, which is Region 5, and that covers Ohio, Indiana, Illinois, and Wisconsin and Michigan. So if you're in the trenching business right now, there is a regional emphasis program in that area, which does give OSHA probable cause to do an inspection. So then we come to the general schedule inspection, and these are all things, information you're ferreting out while you're talking to this compliance officer at the very beginning of his or her inspection, before they've even entered your work site. You want to find out, do they have a right to be here? And so the first thing you're going to do is we want to find out probable cause. Why are you here? And this person says, "Well, it's 1 o'clock. I finished an inspection I had this morning in Dayton, Ohio. And I decided, instead of getting up on the interstate there in downtown Dayton, I was going to drive and pick it up down here in West Carrollton. And as I driving to West Carrollton, I passed your facility here, and I called into the OSHA office, and they said, 'No, this place has never been inspected.' And I said to the area director, I said, 'Well, I've got the afternoon. I'm just coming back to the office, but since I'm here, would you like me to do an inspection?' And he said, 'Sure, that's it.' And I said, 'You say that's the only reason you're here?' And he says, 'Yes, this is the one time you may want to demand a search warrant.' We'll talk a little bit more about this later, but this is the question many of my clients ask many times: should I demand a search warrant? Going way back to 1979, I think it was Barlow tree case. OSHA was trying to do a general schedule inspection without probable cause, and the company said no. The case ended up in the United States Supreme Court. That's an expensive piece of litigation for the employer. But at the end of the day, the U.S. Supreme Court said, "No, OSHA, you have no right to do any kind of an inspection, whether it's criminal or civil. You have no right to access the private business of an employer unless you have probable cause." The employers are protected under the U.S. Constitution to unlawful searches and seizures, and this would be an unlawful search unless you have probable cause. And when that decision came down, for about the next 10 or 15 years, it was almost standard operating procedure for employers to automatically demand a search warrant anytime OSHA showed up without probable cause. In fact, then in that 10 to 15 year period, the employer would send OSHA away, and I'd say in at least 50% or higher, maybe 60% of the cases, OSHA never came back. It was just too much of a bother. Or they'd come back, but they wouldn't come back to 3-4 weeks out. By then, the employer had a chance to put his or her house in order, and it was a worthwhile effort to demand a search warrant. But that's how it was then. OSHA was new, and the court system was new, and how to deal with search warrants with OSHA. And it took a longer time for them to get a search warrant, etc. It's not the way it is in 2020. In fact, it's not the way it's been for the last 30 years plus. Now, if you demand a search warrant, all the compliance officers have to do is go to a federal district court, any federal courthouse, and if it's the state plan state like Indiana, any courthouse, and get a judge to sign off on a search warrant. And all the OSHA compliance officer has to do is swear that he or she has probable cause. And here's why. And of course, if it's a general schedule inspection and they don't have probable cause, the only way they may be able to get a warrant would be a two-step process where they would have to come in and look at your disabled, away from work, restricted duty, your DART rate, or look your EMR or something like that, or look at your, they do have a right to look at your OSHA 300s, please understand that. OSHA can walk into anybody's office who's required to keep a 300, that's any manufacturing, any general industry or construction industry that has 11 or more employees, you are required to maintain an OSHA 300. And OSHA has an absolute right to come in at any time in the SSC your OSHA 300 because you are required to keep them. And you have to produce that within 4 hours, 4 business hours of them making the request. So the search warrant might say if there's an unusually high number of injuries, or if the injury rate is above the national average, or if the DART rate is above the national average for this type of industry, any of those types of things that might get OSHA in there to look at things like your EMR rate, your DART rate, your OSHA 300, etc., and to see whether there's anything there that's squirrely enough to bring them under the language a judge has put in the search warrant. But beyond that, they're not going to be able to do an inspection unless they meet that requirement, or the judge may just deny the warrant, or the judge may grant the warrant and then puts the ball back in your court, because then you have to decide whether you're going to fight OSHA on that warrant and move to quash the search warrant, which will put you in the hands of your lawyer, who's going to have to do a brief, which is going to require some legal research. And the lawyer's probably going to have to come out, look at your facility to determine whether or not there's anything there that would create probable cause, and then prepare a motion to quash, and they're going to have to appear before that judge and argue the case. By the time the dust settles, you've invested quite a few thousands of dollars to try to quash the warrant. And if your lawyer's successful, it may have been well worth the money, especially if you're really concerned about what OSHA might find if they got their foot inside your general industry location or your construction site. Construction sites, it's easier for them to be probable cause because they can stand on public property and take pictures of your site before they even ever identify themselves. They may have probable cause you don't even know about. So always be careful when you're using the search warrant demand, and don't make OSHA wait around. You'll see in a few minutes, one of the things I always tell you is make sure you have a person who's aware of how to deal with OSHA on site. They should be making this kind of a call. And if you have someone like that and they're 2 or 3 hours away, the compliance officer will wait till they get there, but don't make that compliance officer wait 2 or 3 hours for that individual who is your OSHA person to show up. Just have that person say, go get a search warrant. That's going to take off the OSHA inspector, and if they come back with a warrant, I guarantee you they're going to be really looking with a microscope of things that they can cite you for. You don't ever want to Okay, Lisa, I've lost it again. I must be waiting too long between.
Hi, Gary. I'm here. I think maybe just wait a second. I don't know why it's delayed. It fixed itself on your end the last time.
Fix it for me. Not yet, though.
Okay.
So you don't want to use, well, Lisa's working on that. We don't want to use a search warrant, demand for a search warrant, just to delay the inspection to rankle the compliance officer, because if they get back in, still not able to, Lisa. If they get back, compliance officer going to be looking under every rock to try to find a reason to issue a citation. Still not able there, Lisa. Oh, there we go.
Good.
Okay, that's right.
You got it.
Okay, thank you. Let's move on to the opening conference. So now we know why OSHA's come out there. So the first thing we're going to do, presuming, let's forget the general schedule inspection, because I don't see very many of those anymore. Usually OSHA's plenty busy dealing with employee complaints, dealing with national and regional emphasis program or local emphasis programs, and dealing with employers' self-reports. So there's plenty of reasons for them to come out. We don't see the general schedule that much anymore. I had to mention it, but I don't want to get hung up on it. So OSHA's out there now, and the next step, once you've found out why they're there, they're going to want to set the opening conference. They're going to want to meet with a person who's going to represent your employees. Now, your employees may, if you have a union, that's going to be a union safety person. It's going to be your shop steward or anyone else who's got to be, who is designated by the employees to be their representative. You're going to be there yourself. You're going to probably be your safety person there. You're going to have anyone else you feel is going to participate in the inspection there to participate in the opening conference. So here's what the opening conference, typically what OSHA wants to do is a compliance officer is going to tell everybody, here's what I'm at, here's what the rights of the employees are, here's what your rights are, Mr. Employer. I'm here for these reasons, and this is what I need to inspect. Use this for your own benefit. First of all, you're going to ask the compliance officer, how long do you think you're going to be in my facility? A day, half a day, an hour, 2 hours? This is interesting because I did a case a few years ago where my client called me, and the client called me and said, hey, you got to get OSHA out of here. And I said, well, why do I need to get OSHA out of there? I don't understand what you're getting at here. And the compliance officer said, well, or the compliance officer, my client said, well, they've been here for 3 months, and I think they've been here long enough. And my question for him is, why'd you wait 3 months to call me? It's going to be almost impossible to get them out of there now, because the only reason they've been there for 3 months is because they found so much to be concerned about. So let's get that out on the table in the very beginning. Then you're going to ask them, what's your scope of the walk around? And they say, well, I'd like to walk through the whole floor of your entire manufacturing facility, or I'd like to walk the entire construction site. And here's where you say, no, wait a minute, the complaint you're about, or the injury I report occurred on press number 13. As far as I'm concerned, that's the only thing you've got a right to check out. I'm not giving you a tour, a guided tour of my entire facility, my entire plant, or you got an employee complaint that we're not properly protecting employees who are working on the roof of this building with warning lines and safety monitor personal fall arrest equipment. So we'll go up and you can check out the roof, but you're not going to look at any of the other construction activities I'm engaged in here because you don't have any probable cause for those. So you're going to define the scope of that walk around. And at that point, you might wait till you take the employee out to that particular piece of equipment in your machine shop to announce the fact, hey, we're going to go outside and walk around the outside back in this door, and right there's that piece of equipment. You're going to look at that, and when you're done, we're going to come back the same way. You might do it now at the opening conference, or you might wait and do that in a little bit when you're ready to go out. The number of employee interviews, this is critical. OSHA shows up and let's say it's been a self-report, and they say, well, how many employees work around Pete's location? Pete's the guy that got hurt. The machine Pete works on, how many people are in the general area? Well, I've got 10 or 15. Well, I'm going to interview all of them. Well, no, wait a minute, I don't think that's reasonable. You can, I can agree to 1 or 2 interviews, but not 10 or 15. And you're going to, in a little give or take here, you may bring in your lawyer again, but you're going to enter into a little negotiations with the OSHA person here and get it down to a reasonable number of interviews. There's no reason that they have to need to interview 10 or 15 people who are in the general vicinity of where somebody got hurt. Nor do they have the need to interview 10 or 15 people who work in the general vicinity of a machine on which a complaint has been filed. And in fact, they probably have less of a need to interview more than 1 or 2 people on a complaint inspection than they do on an injury inspection. But usually you can negotiate them down to, on a complaint inspection, to 1 or 2, and on an injury inspection, 3 or 4. But you want to limit that, and you're going to say, okay, can we agree you're going to do 3 people? Can we agree you're going to interview 2 people? Well, yeah, I think I'll have enough of that. Okay, fine. Trade secret issues, if you have any, you want to get them out on the table now, and they'll identify photographs and a video they take and protect it. And again, like I said, you're going to identify the employee representative. At the opening conference also, they're going to ask to do some initial records review. Before they ever go out to do the inspection, you're going to want to see your OSHA 300 logs. And they're going to want to see OSHA 300 logs for, let's take right now, 2020. And they're going to ask to see them also for 2019, 2018, and 2017. They go back 3 years automatically. So you're going to look at all those OSHA 300 logs. Why they want to do that? Because they want to look at them to see if there's any trend, either related to the injury that they're out there to check out, or the piece of equipment on which the complaint has been filed, or the work practice there's been a complaint filed about. Have there been any injuries over the last 3.5 years now, since we're almost in the middle of 2020? Any injuries tied into that? Because they're going to, again, that's going to give them more reason to expand their inspection. And again, they may say, well, the complaint was filed on press number 15, and I'm willing to limit my inspection press number 15, but now I notice here that there have been half a dozen injuries over the last 3 years on press number 15. They're all different employees. I'm going to interview each one of them. So the agreement we had to limit it to 3 people, that's off the table. I'm going to need to interview every one of these people who was injured over the last 3 years on press number 15. And you might as well agree to that, because they'll be able to establish a need to do that to fulfill their inspection. They're going to ask to see your safety program. If you're in construction, you're required of a written safety program. You're pretty much required of a written safety program in manufacturing also, general industry. Your hazard communication program, both construction and general industry, you better have one, because everybody has a hazardous material. OSHA loves to say that they consider anything to be hazardous that's beyond drinking water. And usually when I get to this point in the presentation, I say, yeah, today in Ohio, where even the drinking water might be a hazardous material. But no, you need to have a HAZCOM program. Forklift training. Now, if you don't have any forklift or powered industrial trucks, you say that. We don't have any. Okay, then they have no reason to see your training program, because you don't have one. But if you have any powered industrial trucks, you should have a training program. I'm going to ask to see that your entire program, the training component, etc. And they're going to ask to see your personal protective equipment program. Those are things they're going to want to get into as they do their walk around. Now, we're into the inspection itself. Number one, never leave the compliance officer alone. Never, ever leave that person alone. Now, yes, you're going to leave them alone when they're going into a room to do a confidential interview. But remember, we're either going to take them on a construction site, we're going to take them to the job trailer. Don't let them do the interview on the site or next to the machine on which an employee is working. Bring them back to the office area. At least that's a little more favorable ground or more neutral ground for you. But it gets the employee away from that machine they're working on, where they start pointing to things and things like that. Same thing with construction site. It also makes it much more confidential with regards to other employees overhearing what the employees being interviewed is saying. Don't forget, violations observed by a compliance officer. CSHO is Compliance, Safety, and Health Officer, CSHO. Remember, any violations they observe while they're walking through the location to get from point A to point B can be cited, even though they're not connected to the complaint or the injury or anything else. On a focus inspection, we get them to the location, the focus of the inspection as quickly as possible, as directly as possible. And the other thing you need to do is you take the entire inspection very seriously. Now, please understand, compliance officers, especially as they become more experienced, they get a little more time under their belts with regards to how they handle inspections. The more they get under their belts, the more they will try to get you in a comfort position while they're doing the inspection. They may be, as they're doing the informal conference for the more experienced compliance officer, maybe 50% of it's going to be talking about, well, we can't talk about it right now with COVID-19. How about those Reds? What do you think of them? Do you think they got a chance to the series this year? Or what do you think about the Cleveland Cavaliers and whatever is going on? What about that game? They'll talk about just about anything. Or, hey, you're in a pretty good area here. I understand down here in Warren County, I understand there's some pretty good small game hunting. Whatever. They're going to try to get your mind off the inspection, get you into a more relaxed atmosphere, and then every now and then they'll throw in a more critical question. This is why you want to be sure that the person you designate to conduct that inspection, if it's not yourself, has got to be somebody who is very well experienced at OSHA compliance inspections. What's going on in those inspections? What's OSHA looking for? But more important than not, how to go through these steps that we're going to be going through as we go through these, the yeses and nos, etc., how to participate in that inspection. What are your rights and what are their rights? It just shouldn't be anybody. It just shouldn't be the foreman or the plant manager. It should be somebody who knows how to participate in an OSHA inspection and knows the techniques OSHA uses to try to get you to say things that you shouldn't be admitting to, and you might not admit to if you were truly focused on the inspection, but they've got you in this casual frame of mind. And then, how many other accidents have we had on it? I'm out checking out this accident on press number 15. How many other accidents have you had on press number 15? Oh, just 3 or 4. Well, I didn't see those in the OSHA 300 logs you showed me. Oh, those were all more than 3 years ago. You didn't ask to see the log in 2015. Well, maybe I need to see that log too. And all of a sudden, you've opened yourself up to an expansion of the inspection. Now you've given that compliance officer reason to look at your 300 logs at 15 and 16, because you've identified you've had accidents on that press in 15 and maybe in 14 or in 16. You've given them more probable cause to expand the scope of what they normally look at. And that compliance officer might say, well, before we continue with our walk around, let's go back in the office and you pull those 300 logs. Let me take a look at those because I want to see a description of the accidents and the injuries and see whether or not we need to interview more people than we agreed to and previously identified. Next thing is only answer the questions asked. Don't volunteer information. And if you're not sure about whether you should answer a question or not, pick up the phone and call your lawyer and ask them. This isn't something where you're doing a vote. This is something where you want to be sure the person who should be involved is involved in the decision making there. Never lie to a compliance officer. Lying to a compliance officer is looked at as federal obstruction to justice, and essentially that's like 5 years in federal prison per count. Every lie can be a separate count. We don't want to go down that path. I'm seeing more and more reports on the various services I use of employers who are being convicted of lying or making misrepresentations to OSHA and are doing jail time because of that. Quite a few years ago, there was a situation with a general industry employer who was asked to see the training records of his employees for forklift safety training, and he pulled out all these records, and then they showed them to the OSHA compliance officer, and the OSHA compliance officer got copies of those records and made notes of the names, and then he goes out and starts to interview those employees and says, well, what do you think of your training program? how did you feel your hands-on training helped you in being able to operate this forklift safety? And the employee said, well, I never had hands-on training. He didn't know what the employer representative told OSHA or showed OSHA. And here it turned out that you've heard the expression cooking the books. Well, here the employer was cooking the training records, and he had records from people being trained who were never trained. And that employer got convicted of obstruction of justice and did some time in federal prison. Always take duplicate photographs and measurements of those taken by the compliance officer. He takes a picture, you take a picture. And don't say, well, I have a camera. If you've got a smartphone, you've got a camera. And as smartphones get more and more sophisticated, the cameras in them get better and better. And if he shoots video, use your camera again, your phone. But you want to take you want to stand where he or she was standing when they took their picture. You want to stand in exactly the same spot, exactly the same angle, immediately after they've taken their picture. Same thing with measurements. If they take a measurement, take a picture of where they're taking the measurement and of the measurement themselves. They often will take pictures of the measurement itself, but not where they're taking a measurement. Another case I had up in the Columbus area, where an employer was cited for not providing fall protection for employee working more than 6 feet above the ground. Here we had a compliance officer who couldn't find anything to nail this employer for. And they were looking, he was working real hard. So the employee is working along a poured concrete foundation. And the employer had actually brought in dozers to push dirt up so that the distance between the working surface and the surface below was about 5 feet 10 inches, not 6 feet. No requirement for fall protection. And there was one area though in a corner where an employee was working outside the guardrail, or where there was a guardrail, I'm sorry, but so there was a guardrail, there was nobody working there. And the employee could do his work from inside the guardrail, and the employer had not brought it in there. And when the compliance officer took a measurement, it was 6 feet 1 1/4 inches. And my client had actually taken a picture of the location. He showed the tape measure exactly where the person was, took the measurement. And then I was able to get an affidavit from the employees who worked in the area saying we always work from behind the guardrails. We had no reason to be outside the guardrails. And we won that case again. The area director withdrew the citation because she couldn't prove we had anybody working exposed to a fall of greater than 6 feet without fall protection. The next bullet, I should say, take lots of photographs. I apologize for the typo. Lots of photographs and ask for samples. Then pay attention. Is a compliance officer videotaping or videoing or tape recording any part of the inspection? Now, again, you're not going to know if they're tape recording or videotaping confidential interviews. They should be asking the employee if they object to that and let the employee go on record to say they are. They still will probably proceed, at least with audio recording the interview. But most compliance officers don't audio record interviews, because I found that some compliance officers say things during the interview they don't want to end up being on a tape that eventually will be discoverable. But you want, if they're videotaping part of the inspection or if they're audio taping part of the inspection, you need to know that. And you need to, once again, take the same video they've taken. And if they're audio taping, you want to pick up the same thing and tape record that on your phone. If they take air monitoring, again, you take photographs of the area in which air monitoring is being taken, whether it's inside a manufacturing facility or outside on a construction site. You want to take photographs, or you want to make note of the environmental conditions. There's a 20-mile-an-hour breeze blowing and low humidity, etc. Or let's say high humidity, no breeze, no air circulation, etc. Whatever. You want to make note of that. You're going to take a photograph of where they hang the monitoring equipment on the employee. And it wouldn't hurt to have someone keep an eye on the employee who's being monitored to make sure they don't intentionally try to contaminate the sample. Because the compliance officer is not going to stand next to that employee for the entire shift or the entire period of time he's getting the sample or she's getting the sample. They're going to want to get on with the rest of their inspection. So you want to be sure that somebody's at least spot checking the employee to make sure that they continue to wear the monitoring equipment where it was placed and they're not doing anything to contaminate the sample. Never volunteer information. This is part of their goal to get you in a relaxed atmosphere. They ask you a simple question and you can answer with a yes or no answer. That's it. Answer with a yes or no answer. Don't say, well, yeah, but you should know about this, or you should know about that. That's the wrong way to go. Take notes of everything the compliance officer does beyond the photographs you're taking, the measurements you're taking, etc. You want to make notes as to what they're doing, where they're going, and who they're speaking to. While you can't sit in on a confidential interview, you sure as heck can make a note of who that compliance officer talks to and how long they talk to them. That's a question I frequently ask my clients after we get a citation. Well, who did he or who did she interview? Well, Joe, Pete, and Bill. Well, how long did they interview each one of them? Well, I couldn't say, probably 5 or 10 minutes. And then I found out later on that they were half an hour, 45-minute long interviews. These are all important things as we start trying to make decisions if citations are issued. You have to always permit confidential employee interviews. You have no objection to that. But that's why at the opening conference, we're trying to establish the number of those interviews. That's this next point. That should have occurred at the opening conference. But if you forgot to do that at the opening conference and you got to be interviewed 2 or 3, it's a perfect time at that point to say to the compliance officer, I know, we didn't talk about this before, but aren't 3 interviews enough? Well, I want to take more than 3 interviews. I'm thinking I want to take at least 7 or 8 more interviews. No. We're going to have a discussion about this. You take this interview, then we'll go back to the office and chat about it. At that point, you may want to get your lawyer on the phone, or you may want to call the area director and say, this is getting a little bit crazy, and try to get them pulled back. You don't want to make it look like you're trying to hide anything, but don't forget, OSHA has a right to do inspections, reasonable inspections at reasonable times, and that includes reasonable length of times and things like that. They don't have the right to make an employee complaint that you weren't issuing safety glasses to all the employees. That shouldn't give rise to a 5-day inspection. So this is where you want to try to control those things. Enforce all the safety rules you have in place. If while you're doing the walk around, you observe an employee violating one of your safety rules, enforce it. Hey, Pete, come over here. Where are your safety glasses? Where is your hard hat? Where is your personal respiratory protection equipment, etc.? And I'm going to have to write you up for this, under the program. I'm not sure what step you might be at. You're going to go up to the next step and consider this to be your verbal reprimand, and we'll follow through with whatever level of enforcement you're at in our program. And get away from that machine right now and get the necessary PPE before you continue to operate it. Or why are you operating that machine with the guard? Did you use 2 alligator clips and a piece of wire to wire around the magnetic interlock on that guard? Oh, that's a serious violation. You got 3 days off right now. You go to HR. I'll call them right this minute. You get on your phone and call HR and say, I'm sending Pete out to you. I just found out he hot wired a guard on his press he's working on. That way, yes, you're admitting the person did it, but the OSHA compliance officer has already seen them doing it. But by enforcing your safety program, you're going to have a much better chance of using the unpreventable employee's misconduct defense to defend yourself down the road. Speak to the compliance officer. We talked about that. Remember, the information obtained during the confidential interview can result in an expanded inspection. We've already talked about that, and we've already talked about enforce safety rules. On a construction site, the compliance officer is going to ask to see the competent person. And now, those of you in general industry, don't forget, since OSHA morphed some of the construction industry standards on January 17th of 2017, they morphed some of the construction industry standard on scaffolding and fall protection especially into general industry. And the scaffolding standard especially, that's now part of the general industry standards, has a competent person requirement. The definition of a competent person is found at 1926.32 lowercase f close paren. So if you're a general industry but you're using scaffolding, you need to go and find out. First of all, look at the standard. It's going to tell you need a competent person to be present and to supervise erecting scaffolds, dismantling scaffolds, and moving scaffolds and scaffold systems. And you need to go to the standard I just cited, 1926.32F, to find out how they define that competent person. For those of you in construction, these 5 areas all require the presence of a competent person the different extensions. And there's more to the competent person requirement and scaffolding that I've already mentioned, but you want to be sure you've got that person available. Okay, closing conference, this may be done in person or by telephone. You're not going to get anywhere, so avoid getting into an argument with the compliance officer regarding possible citations. You're not going to change your mind. All you're going to do is maybe antagonize them. Because by the time they've called you, they're just going to tell you, this is what I saw, this is what I'm going to be recommending to the area director, and nothing you're going to say to them is going to change that. Do not agree with any of the violations. So, oh yeah, I guess you caught me on that one. Oh yeah, I guess you don't make those kinds of admissions. Compliance officers making a note during that conference, that call. They're not tape recording it, but they're making a note of things you say. And they'll testify to it later on. Oh yeah, he admitted to having committed these violations and never gave me any reason for them. They're going to work against you. You just listen, listen, and listen. And if the compliance officer tells you, well, yeah, this was going to be the closing conference, but I decided I'm going to need to expand the inspection, now's a perfect time to bring in legal counsel to find out what the chances are of preventing that from occurring. Okay, then you go to the citations. When the compliance officer leaves, finishes the inspection, he or she completes what's called the narrative OSHA 1A form. And I just put this up here because these are things that go into that form, and these are all things that they consider when they're trying to decide what citations are going to be issued and what the cost factor is going to be, or the classification of those citations are going to be, other than serious, repeat, or willful. These, I'm not going to spend a lot of time on these because they're self-explanatory. This is just information they're seeking. But let's go over here. And one of the things they're asked to do in part 7 of the OSHA 1A, they're asked to evaluate your safety program, your training program, and your employee knowledge of safety enforcement program. And they're going to give you below average, average, or above average. And these things go into the penalty assessment, how much they may assess you for a penalty on citations they issue. And they also can affect whether or not you get any reduction in fine for good faith. So these are things they're looking at. When they ask to see these things, there's a reason, because they're evaluating them, and that evaluation is going to come in the final assessment prior to citations be issued. They also will have a written narrative containing an accurate and concise information about you and the work site, and the date of the closing conference was held, and a description of any unusual circumstances that occurred, and then any other relevant comments that a compliance officer feels he or she should make, the names, addresses, and phone numbers of other persons contacted during the inspection, and the names and job titles of any individuals who accompanied the compliance officer. And this goes on. They calculate your DART rate. That's a numerical calculation. There's nothing a whole lot you can do about that. Discussions clearly addressing all items of any applicable complaint or the referral that got them to your site. They're going to discuss those items there. Type of legal entity, whether you're an LLC, a sole proprietorship, etc., and coverage information. Okay, then we get to post-inspection. Your citations are issued, consult with counsel, and you want to consider the impact beyond just OSHA of those citations. And, let me skip ahead here for a minute. Before we get there, I want to get to this. We're going to get to that material here in just a minute. These next several slides, I'm not going to spend any time on these because I want to get into post-inspection and post-citation considerations. These are the earlier slides that I've covered with you, but I've taken these and I've done this for one of my clients, and now I'm sharing it with you, and I share it every time I give this presentation. These are do's and don'ts for doing an OSHA inspection. So everything that I just do in a more of a narrative form, I'm just going to roll through these, but I've got some clients who actually, and you're going to get a copy of these slides. If you choose to, you're more than welcome to. They actually printed out these do's and don'ts slides, and they give those to their knowledgeable person within the company. They give those to them and they say, okay, keep these with you. And if OSHA shows up, take a quick look at these or take them with you and pay attention to them. If something comes up, look at what an attorney says you have to do or you shouldn't do. So number one, I've already mentioned that knowledgeable person that you want active inspection to conducting inspection, or someone you can rely upon who has that knowledge. And then here we go. Don't. We've talked about that. Don't automatically demand a search warrant. Don't permit OSHA inside your facility or onto your job site until your knowledgeable person is there. They'll give you up to 4 hours to get that person to the site. But once again, if you ask for that time, then don't use it to keep the compliance officer cooling his heels if you've already made a decision you're going to demand a search warrant. That's ridiculous in my eyes. It's definitely ridiculous in the eyes of a compliance officer, and it's going to result in a much more antagonistic inspection. Always request to see a compliance officer's credentials. Ask them to obtain the reason for the visit. If it's an inspection based on an employee complaint, don't show the compliance officer more than the subject of the complaint. Be courteous. Don't be casual. Don't argue with the compliance officer. You can't win an argument with them. Don't volunteer information. Do answer questions to the best of your ability. Do answer only the question asked. Do ask if anything you're saying is being recorded. If they're recording on their phone, ask, are you recording any part of this? And if they say yes, say, I don't want to be recorded. And if they say, well, I'm going to do that anyway, then you can always say, well, I'm not going to answer any questions. That's your call. Be aware of any videotaping that's being done. Don't ever leave them by themselves. Do permit them to conduct confidential interviews. They're entitled to do that by law. Do note any interviews by the compliance officer, who they talk to and how long. Do attempt to participate in any management interviews. Don't forget that once you declare a person as management, so you can sit in an interview, then they become your agent, and things they say can be used to get you. Because those are like the company. This is what they're speaking for you yourself, actually, at that point. Don't permit them to direct your employees. Don't permit them to have a private interview discussion. Private demonstration, of equipment under the color of a confidential interview. No, they don't do a confidential interview and have the employee while they're interviewing them do that. If they want to see how the piece of equipment is run, that's something you might want to run by your counsel. Don't permit them to hold group discussions. You want to do individual interviews, that's fine. We're not going to talk to 15 or 20 people here in this construction site all in one big group. Or nowhere are we going to call people in our general industry manufacturing facility together so you can talk to 4 or 5 of them at the same time. Don't ever lie. We've already talked about all these. Do be sure that if they're observing an employee operate equipment, the employee is operating it according to established procedures. Don't permit them to conduct experiments. I'm going to roll through the rest of these because I want to get on to the rest of this material. Okay. Records request by OSHA. Safety data sheets for all hazardous materials must be done immediately. The OSHA 300 laws, you have 4 business hours to produce those. Confined space evaluations, you need to have those available and produce those immediately. Your PPE hazard assessment, you may be given time to produce that. If you have a safety or an injury illness prevention program, that's what an IIPP is, and you'll have time to produce that. But not, you want to do it immediately, but you're going to have to do it within a day or so. And then training records, the same thing. Lockout, tagout program evaluation, if it's applicable. Heat illness prevention program, if it's applicable. Initial exposure assessments, again, something like respirable crystalline silica, if applicable to the work that's being done. Okay, now the citation's been issued. You're evaluating the citation. The next step is an informal conference, whether or not you have one, then a notice of contest, and I'm going to go through this with you now in a little more detail. First of all, you're going to carefully review the standards that are cited. You want to make sure that the standards that have been cited apply to the work that's being done, and you're going to look at the language in the citation to be sure that they properly quoted what's said in the standard. Sometimes they take a little bit of literary license, and they may word what they're saying is in the standard. They're saying you violated it differently than the standard requires. That may give you a defense right there. So it's one of those things you want to look at. And at this point, you may want to have your attorney involved. Determine your liability. Do you have a violation, or do you have defenses? Affirmative defenses such as unpreventable employee misconduct. And then what's my course of action going to be? Many of the less serious citations come with what I call an informal settlement agreement. Actually, it's usually a 1 or 2 page document, which is part of the citation package. And if you sign it, OSHA automatically reduces the fines by 30%, but you agree that you violate all the standards that they've cited. So that's one step. The next step is, do I want to do an informal conference, or do I move directly to a notice of contest? This is something, these 2 points are something you should chat with your attorney about. And I'm saying chat with your attorney because your attorney knows the law. He or she knows the case law. They know how the review commission is deciding cases like yours. They've also had experience in dealing with these cases, and they know, as I know, that cases are seldom won at an informal conference, but they have been lost at an informal conference because the employer walks into the informal conference and starts unburdening themselves and getting into an argument with OSHA, and before you know it, they said things in the heat of the argument that they shouldn't have said, or they've made admissions they never would have had to make that end up making it much more difficult to defend the situation later on. Moving directly to a notice of contest is sometimes a viable alternative. Again, all those decisions come from these points, these questions. Are the facts as stated correct? Are they, was anyone in management aware of the alleged violations? Employer knowledge is one of those things that they have to tell you about, or you have to, that you can use to defend yourself. Standards side correct? Has a general duty clause been properly applied? This is becoming a much more viable defense than it used to be. But again, here's where you want to talk to your attorney about it, who's familiar with how the case law on this defense is developed. If an employee has employee misconduct involved, and if a defense is available, is it affirmative? That's unpreventable employee misconduct. Legal, that's a general duty clause, or factual. The facts are not as you say them, like the case I mentioned I did in Arkansas recently. And Lisa, I've lost my control again. Sorry, kiddo.
Yeah, that's okay. I think it just delays sometimes, but I'll check something out. So you can keep talking and I will, yeah.
I may have done something.
No, Gary, I don't think it's you. I think it's just delaying for some reason. Let me check something.
On here in my material so I can move around while Lisa's trying to fix this for me.
Try it again, Gary, because you're still as the presenter.
Yeah, I'm not.
It's not working. Okay.
Okay.
I will.
Okay, still don't have it. Let me move on. The next slide is the course of action we talked about, and you'll see these slides in the informal conference. There, typically, I suggest informal conference only if your only goal is to reduce the penalty. If your goal is to get more than that 30% automatic reduction of penalty, then the informal conference might be a viable alternative for you. If, however, you want to try to get the citation reclassified, especially if you're trying to get it reduced from a willful to a serious, or from a repeat down to a serious, or from a serious to an other than serious, you've got an uphill battle in your hands. Please be aware of the fact that a general duty clause citation will not be reduced by OSHA to an other than serious. They're automatically serious unless they're repeats or willfuls, but they will not be taken down to other than serious because the general duty clause violation states you have the obligation to provide your employees with a place of employment that is free of recognized hazards that are causing death or serious physical harm. And because of the language in the general duty clause, they automatically have to be treated as serious. So the informal conference, you're going to meet with the area director. Always have a game plan going in. I frequently do outlines for clients. I don't recommend taking an attorney. I think it's a waste of your money. It may show that the area director that you got plenty of money. He doesn't have to reduce the fine as much as he might have thought he needed to if you're in there to plead a little poverty. So I don't take an attorney, but always have the game plan. Have your attorney give you an outline that you can follow. Still not moving there, Lisa. And always be aware of the field operation guidelines field operations manual guidelines that will tell you what the authority of the area director is. Most recently, the area director is restricted on how great a reduction they can give you on the penalty, and again, as to what their authority is to reclassify. And the next several slides you can read for yourself because they go through the field operation manual guideline changes back on April 22nd, 2010. There have not been any significant changes since then. And basically what they say is the penalty calculation, they talk about expanding the covered periods from 3 to 5 years. So when they're looking at your history, rather than going back just 3 years, now they go back 5 years. And what they've done is they added back in 2010 so that when they look at your history, and history can reduce the penalty. It won't reclassify the citation, but let's say you got a serious and the initial penalty was $3,000. So what the history could do is reduce that by 10%. But now, as 2010, they've also said if you have high gravity, serious, or willful repeat in the past, or a failure to abate in the past, they can increase your penalty by 10%. So know what might happen if you get in certain arguments with regards to penalty calculations. And you may not have that information available to you going into the informal work already anyway, but if you do, just be aware of what could happen. There we go. Okay. That's the area director authority I was just mentioning. Thank you, Lisa. And these are the various penalties. That's self-explanatory. Size reduction changed. It used to be prior to 2010, 1 to 25 employees, an automatic 60%. So in the gravity-based system here, let's say you were at the 7,000, the top of the serious. And you get to, you've got 22 employees. They're going to take 40% off that 70,000, that 7,000 to begin with. So automatically, you would come down to by 4,200. Now, of course, we're in a new penalty situation now, where we're now at 12,740 as of 2015. We're now up into the $13,000 numbers because this goes up by the Consumer Price Index every year. So we're up by 13,000. So this 60% reduction at that used to be is now 40% reduction if you're under 25 employees. 40% of a $13,000 penalty will take it down about $5,200. But it used to would have taken it down by 60%, a much more significant amount. So good faith is a defense where you basically argue that you've got a safety program, an effective one that's in place, you've got an enforcement program which you're using, etc. You can get up to 15% reduction. After they take the size reduction, then they'll take another 15% or up to 15% off. But these are automatics. These are in the calculations that OSHA is going to use. And if you file a notice of contest and get the discovery, you'll learn how they apply these things. And you can go back and argue with the area director because you've got the ball is still in the court. Don't forget, after you get the citation, you have 15 working days to either settle the case with OSHA or file a notice of contest. If you fail to do either one of those two things within 15 working days, that does not count federal holidays, 15 working days, you will pay the fines for the citations as issued. Wherever they are as they were issued, you've lost your right to argue. Now, there's been some recent case law, I don't even have up here because it's not recent, that gives you a little more latitude if you can show justifiable neglect in failing to hit that 15-day mark. But it requires some really serious situations like, well, you know, the citation, according to the certificate here, the person who gets our mail signed for these citations on May 21st of 2020. And then we had a reduction in force and she lost her job on May 25th before anybody else got to see those. And they ended up laying on her desk. And before we got around to even starting to audit what she had and what was in her desk and everything, we were outside the 15 working days. Something like that may, and I underscore the word may, be enough to get you a day or two more than those 15 working days. But please, the most simple thing is follow the rules here, because trying to get an exception to that's going to require you to bring an attorney in and start going to cost you some real money. And unless you're talking some major penalties or major classification issues, it may not be worth it. You can also get a 10% reduction if you have a strategic partnership agreement, that was eliminated. I'm sorry, that was eliminated. Okay, so we file a notice of contest. We're only going to do this under careful consideration. know what you want. Again, here you should talk to your lawyer. In some cases, in many cases, I'm seeing situations now where the OSHA, where the Secretary of Labor lawyer brings the an OSHA person back into the case. The case in Arkansas, I advised my client, I said, look, instead of doing an informal conference, because I knew my client, this is like the third case I've done for him over about 7 years. And I said, let's not do, why don't you let me file a notice of contest and let me deal with it. He said, sure, you know what's best, Gary. You've never led me wrong before. Go ahead and do it. So I filed a notice of contest. The case gets sent to the OSHA attorney. She files, it's automatically given simplified proceedings, which we'll talk about here in a minute. And I removed them, but long story short, she sent the case back to the OSHA office in Dallas, the Dallas, Texas regional office, which covers Arkansas. And I get a phone call from a woman at the regional office, explained everything to her. She, lack of a better terminology, dilly-dallied around for about 3 weeks. I did nothing. I didn't have anything I had to do. And I get a phone call out of the clear blue sky, and she said, are you sure you aren't willing to sell it? I said, no. I said, you don't have a case. You can't win this. We're going to get this vacated. And she said, well, we're going to withdraw it. She said, we're not going to do that. She's aware of a little law that's out there called the Equal Access to Justice Act. If you're a small employer and you fight a case and you win it, you get your attorney's fees reimbursed to you from OSHA. So it's something, again, to think about if you're a small employer. So, like I said, the informal conference, I only use that if you're talking only about the penalty. But if I'm worried about getting these things reclassified or getting a citation vacated, then I'm filing a notice of contest. The union and party status. Also, remember back here, if you file a notice of contest, you're going to proceed down a certain path. You can pull back from that path just about at any time, but you are automatically, as part of that, if in the simplified proceedings and automatic, under standard proceeding, you have to ask for them, you're going to get a copy of the OSHA inspection file. And I always tell my clients, I need to see that before I can really advise you on settlement. But please, before you accept a citation just on dollars, let's say, I don't care whether you're a general industry or a construction industry employer, you were cited for 2-3 serious violations and these penalties, and you're saying to yourself, you know, we didn't do anything wrong, but OSHA's not going to back away, but they've offered 50% off the penalties. Right now, we're looking at penalties of $30,000. They'll take them down to $15,000 if we accept the citations. If you really, truly believe you can win them, just chat with an attorney, get their analysis on the case. In the last several months, I've ended up in 3 cases, all repeats, all $50,000 plus fines on cases my client said, yes, I settled it 3 years ago. I settled it 4 years ago. I settled it 2 years ago. And I only settled because they gave me a really good deal on the penalty. I really didn't do anything wrong. And then I tell them, well, that's really nice, but you admitted to doing it wrong now, and we can't bring up the fact that you never really did anything wrong 3, 4, or 2 years ago. You're stuck with that. And all now we can do is you have to defend the repeat, and that you saved, in those cases, they say one guy saved $5,000 in fines, the other guy saved $3,000. Can't remember the third case. And now we're talking $50,000 plus. So you say that $5,000, I'm happy with the deal you got, because now you're looking at some real money. So simplified proceedings, this gives you the bullet points on what happens there. These are a hurry up procedure the judge uses. There's no discovery. The judge sets a date for a hearing at the same time he sets a date for a pre-hearing conference. Rather than a conference call to set a hearing, which under standard proceedings you do. You set the hearing date and everything else. And in the pre-hearing conference call, which you don't get in simplified proceedings, there's no discovery. Typically, you try to narrow issues and things like that, but you've already got all the judges interested is you're either going to settle it or you're going to litigate it. But don't forget, in simplified proceedings, you can always try to object to those simplified proceedings and get the standard proceedings. Again, you've now got your attorney involved. You want to be guided by that person's recommendations. Simplified proceedings are not available in cases involving a fatality, a willful or repeat citation, or in a case where the proposed penalties are greater than $30,000, or if they expect a hearing to take more than 2 days. Standard proceedings, the DOL attorney, Department of Labor attorney, will file a complaint your attorney's going to file an answer and a request for discovery. The nice thing about standard proceedings is if there's something squirrely about the inspection, you want to depose the compliance officer. I've got that going for me in another case I'm dealing with right now in Missouri, where we removed it from Simplify because I wanted to depose the compliance officer because I think the compliance officer's way off base. And then I get that right under standard proceedings. And when you file your answer, you state affirmative defenses. In simplified proceedings, you can raise affirmative defenses, but you do those at the scheduling conference. In standard proceedings, the judge sets a pre-hearing conference call, sets a date and time, and also the discovery schedule. Discovery is permitted, and post-hearing briefs are permitted. Even in simplified proceedings, 95% of the judges ask for post-hearing briefs, and 5% will permit them. Post-hearing procedures, after you get the judge's decision, then you can accept it and pay fines or whatever, deal with whatever you've got, or you can file a petition for discretionary review with the review commission. That was a Sturgill case, for example. And if it's not directed for review, the judge's decision becomes final. In Sturgill, it was directed for review, and the review commission reversed the judge's decision. And then finally, beyond that, you can go into the Court of Appeals. And again, you need to look at the seriousness of the situation, but also look at what's the likelihood I could get a repeat of one of these things that I mean that's either wrongfully decided against me, or I don't want to have to pay the fine or pay the cost of litigation, so I'll settle it. What's the chance you're going to repeat that in the next few years? Remembering things that employee complaints are increasing almost every year, so the opportunity for OSHA to come out and look at one of your job sites and find a repeat of that thing you settled to save $5,000 in fines 3 or 4 years ago is increasing frequently. And the review commission directs review of the briefs by both parties, and then there's usually oral argument at the review commission in Washington, D.C. And then, like I said, post-review commission goes to the federal appellate court within the jurisdiction where the citation was issued, where your company's located, where its headquarters are, or the District of Columbia Circuit. Then state OSHA, most state OSHA procedures are completely different. The procedures after the citations issued are completely different than federal OSHA. I'm not going to take the time to go through the states that I'm familiar with, which are legion or a legion of them, but many of them don't have the informal conferences we know of. So you need to familiarize yourself or your representative to be familiar with those state OSHA procedures. And as I have to do when I represent clients in like the state of Washington or Nevada, I have to get licensed to practice. I absorb those costs, but it is a procedure and a fee I have to file to be licensed to practice in those states. And most states take a much more fixed position on settlement. State of Washington will not negotiate settlement. I can tell you that right now. And that's it. So Lisa, I think we got about 3 minutes. Do we have any questions?
Awesome. That was absolutely fantastic, Gary. Great information. Everyone, if you would like to ask a question, please utilize your chat bubble. And Gary and I we will read that question.
I've got 2:30, or I'm sorry, 1:30.
So if anyone has a question for Gary, please type it in using the chat bubble.
Going once.
Feature. He's available to answer a few questions if anyone has one.
Okay, well, remember what I said, folks. If you want to email me at my email address, if you have a question, you didn't get it in the chat, you're still on the call, on the webinar, please do not hesitate to email me the question or call me. Just please identify that I participated in the Dayton Valley Safety Council webinar that you did, Gary, on May 28th, and you'll get it over the next, I'll extend it for 60 days. Over the next 60 days, if you get some, I'll be glad to answer the question for you one-on-one if you don't want to send it in, because I think, Lisa, we're out of time.
We are. And Gary, yes, no questions. I think that tells us that you were very thorough and covered all the information. So thank you so much. And I want to let everyone know that I will be sending out Gary's slides as well as the article that he mentioned at the beginning of the training. So you will all receive those this afternoon. And the webinar has also been recorded, and that will be available in your Chamber Member Hub, so you can access that later as well. Gary, thank you so much, and I hope everyone has a great rest of their day.
Okay, Lisa, there was one question. Somebody asked whether they get a certificate for attending. I don't know if you saw that or not.
There we go. I don't think we will be doing certificates. We have the attendance log and it has everyone that was logged in and attending. So that's a great question. Thanks, Gary.
Okay, thanks, everybody. I'm signing off. Thank you, Lisa.
Thank you, everyone. Thank you again, Gary.
Bye now.